Grant Quenstedt, Quenstedt Law Firm here in Schertz, Texas, right outside of San Antonio. Thanks for joining me again.
Sure thing, Matt. Thanks for coming out to the office today and setting up all the equipment to film here. It's a pleasure to have you here at my office.
Yeah, man, appreciate it. And every time, I always say it, so every time I get on the road on 35, which I did on the way here for a minute, I always think about our conversations about 35, the Texas corridor, the Texas Triangle, and obviously personal injury and horror stories and car accidents.
It's a rough time to drive on 35 right now with the construction that's going on. I feel like you're really taking your life into your hands every time you get on 35, and so please be careful out there. Please use your following distance and really be aware. Make sure you're not distracted and be aware of what's going on around you, because the construction, the lanes are uneven. The lines, the markings in the lanes are not correct, and so you have to be on really high alert to make sure that you're driving safely through these construction zones.
Yeah, and I had a commercial tractor trailer truck that was on kind of the far right lane, and I was to the left of him. Just start coming on over, and I must have been in his blind spot or something, but it wasn't like it was low traffic. There was traffic everywhere, so I assumed someone was merging in from the right side. But made me think of our conversations. Also made me think about Texas overall, and I guess not a lot of drivers are aware of what happens if there's a commercial vehicle accident, like say 35. What typically happens in those first few hours that most people in my shoes are unaware of?
Sure. So in these commercial vehicle cases, these large trucking companies and the commercial companies, they have their own attorneys, they have their own risk management people that are going to respond to these incidents, and they're going to start gathering their own information. They're going to start the narrative, and the initial narrative is going to be to the police when the police arrive. They're going to control what is said to the police. They're going to control what is said to 911. They've been trained, they've thought ahead of time about these things happening, because they're going to happen. Statistically, they're going to happen. And so, when something does happen with a commercial vehicle, you need representation quickly. And the faster that you can get representation and you can get somebody on your side to start gathering that information and to start preserving the information to make sure that it's not lost or destroyed, the better chances that we can help you with your case. The faster that we get involved, the better chances that we can help you. If you come to me, a month later or 6 months later, can we still help? Maybe, depending on the circumstances and depending on what happened in your case, we can certainly still work on that case. But we're going to have a lot better odds and a lot better chances of success if you come to us right away, so that we can gather the body cam video. We can have the data downloaded from the 18-wheeler's black box, so to speak. Mm-hmm. We can have accident reconstructionists visit the scene and measure the skid marks and measure the gouges in the road before they're lost or covered over. And so there's a lot of things that we can do right away when a crash happens that can really make the difference in a case.
Because I've heard not every big trucking corporation or anything like that, not all of them have this playbook, but it's my understanding that many of them do have these specialized teams that'll go out, and they've got an attorney on speed dial. They've got someone who will come out literally to the scene of the crash, sometimes beating law enforcement, which I think is hilarious and crazy at the same time. For the same purposes. I'm a business owner, and we do certain things, as a business to make sure that we're mitigating our liability as best possible. So I can understand, why they probably do have those teams to go out and survey and everything. And I think there's also some that have deviated in a different direction, almost to control in their favor, a case outcome as well.
Absolutely, yes. I mean, they're risk management folks. They know how the system works. They're going to work the system in their favor, however they can. And so they've been trained. The drivers have been trained on what to say, what not to say. They're never, or they should never. They're trained to never accept responsibility for a wreck happening. Because they don't want to have that liability on themselves. They don't want to have that liability on their company. And so you need somebody fighting in your corner who's going to, counteract everything that the company is doing to not take liability. You need somebody fighting to prove who was actually liable for the wreck happening and to hold those companies responsible if they are responsible.
And let's say the company is responsible, or at least that's, say a client coming in your purview. If they're saying, hey, I wasn't at fault, it's this big company, how does that process typically work?
So it really just depends on the situation. In some cases, we will file lawsuits right away. And when we file a lawsuit, that opens up a whole set of tools to our disposal. So once we file a lawsuit, we can subpoena information. We can, ask the court to order defendants to preserve a vehicle, for example. If a 18-wheeler is involved in a wreck, and we need that vehicle preserved so that it's not repaired or it's not disposed of. There's a lot of things that we can do if we need to right away. In some cases, if it's a more simple situation where everybody agrees this is what happened, where some of this stuff is not quite as critical, we might wait on filing a lawsuit until we find out if we need to. We can always file a lawsuit as long as we're within the 2-year statute of limitations. We can file a lawsuit at any point in that time period. So it's really a fact-specific question whether we need to file it right off the bat or whether we can delay that process of filing and try to get your case settled without filing a lawsuit. If we can get the case settled without filing a lawsuit, it has the benefit of being less expensive. And so lawsuits are expensive. There's a lot of costs involved with filing it, with taking depositions, with hiring experts, so on and so forth. And so we can definitely do that in cases where we need to, but we just want to make sure that what we're doing is actually necessary and is actually leading to a better result for the client.
Nice. And, you had mentioned something kind of scary, I guess. So for the big 18-wheeler, trucking companies, is there a time period legally after an accident where they have to preserve their own vehicle or not act on it, or it just boils down to speed of action in terms of starting the suit process? What does that look like?
So one of the first things that we do in any commercial vehicle case is we send a preservation letter. And so we reach out to the company and we say, hey, look, we're representing this person. They've been injured. We believe that your company or your driver, were negligent in this incident, and we're asking you to preserve this information until this case has been resolved. Mm-hmm. And so the sooner that we can get that letter out, the sooner that they have the legal obligation to preserve that information. There are a number of laws. So the trucking industry is governed by the Federal Motor Carrier Safety Regulations. And so that's an entire rule book that lays out everything that a motor carrier has to abide by. And so they have their own set of regulations about, you need to preserve maintenance records for so many months. You need to preserve drug testing results for so many months. You need to preserve driver qualification files for so many months. So all of that is laid out, and all of that is something that comes into play if you end up in a lawsuit. You go through that discovery process and you require that company to prove that they have followed all the rules that they're supposed to follow.
Yeah, and outside of the commercial vehicle accidents, talking about the kind of the burden of proof, we had talked before about uninsured motorists and underinsured motorists. Uninsured motorists is always an interesting one because talking about burden of proof, it's kind of on the person who gets hit to prove what happened, right? And then that also begs the question of, we talked before about, the Texas minimums haven't been adjusted since 2011.
Right. Yeah. So since 2011, the minimum amount of insurance required by law in Texas is $30,000 per person with $60,000 per wreck. And then the minimum limits on property damage liability is $25,000. Like an average new car, I think I looked at the averages the other day. I think an average new vehicle is up close to $50,000. And so the reality of the situation is someone could total your vehicle. Say you bought a brand new, you bought a brand new vehicle, $50,000. Somebody runs into it and totals it. Their insurance is going to write a check for $25,000, and that's all that's going to be available. And so you have to, in that situation, you have to have your own coverage, or you're out $25,000 or whatever the cost of your vehicle is. And so it's kind of insane to think about. Most people who drive a $50,000 vehicle, for example, they have collision coverage that's going to cover the vehicle. They have comprehensive coverage that's going to cover it if it's stolen or if it washes away in a flood or anything else happens to it. But then a lot of these same people, they don't have the coverage that's going to cover themselves, their bodily injury coverage. And so that's something that I really just try to stress to people is the reality of the situation. And I talk about it a lot because it's such an important topic, and it's something that I have to explain on an almost daily basis to my clients and potential clients is here's the most that we can get for your case. The most that we can get for your case is how much is available from the other person's insurance coverage, which in many, many cases is $30,000. And then if we use all of that up, then we look at your own insurance. And I get a lot of pushback from clients. They're like, well, I don't want my insurance to pay out because somebody else was at fault. Okay, well then stop paying insurance, right? If you don't want to use your insurance that you've been paying for, why are you paying for it?
Yeah.
Right? And so I have to have that conversation over and over again. People find it very unfair. Well, it's not fair that my insurance has to pay out because somebody was negligent. Okay, fairness, life is not fair, right? No one ever promised you that life was going to be fair. That's the first thing. Second of all, if you have this coverage, now is the time to use it. If you have the personal injury protection, if you have the uninsured, underinsured motorist coverage, now is the time to use it. And if you're not going to use it, literally call your insurance agent and cancel the coverage, because there's no other time that you're going to need this coverage. If you're injured and you've been in a wreck, now's the time. This is what you've been paying for this coverage for.
So in addition to uninsured and underinsured motorists and kind of padding that up to the best extent possible, what do you think people can do to better protect themselves in advance of getting hit by another vehicle?
Yeah, so what you have to do in advance, aside from buying the appropriate insurance, and I'm willing to talk to anybody. If you want to give me a call and talk insurance, I will talk insurance with you. If you need a recommendation for who to buy insurance from, I know some great people in the insurance business, happy to provide recommendations. But buying the appropriate insurance is I think the most important. We've talked about dash cameras. Have a dash camera in your vehicle before you get in a wreck. Doesn't help you after you get in a wreck. And so, having an attorney in mind. Go ahead and save my number, 210-888-9953. Put it in your phone now. Label it as attorney. So when you need an attorney, you know who to call, because you're going to be, when a wreck happens, you're going to be stressed out. You're not going to be thinking clearly. You're going to be vulnerable to people that are trying to take advantage of you. And so a lot of times people get in wrecks and then their phone starts ringing. And it's what we call case runners, people that have obtained your information, often illegally or unethically, and they're calling you to try to funnel you to some law firm that is paying them for those leads. And often these law firms are in other cities. Sometimes they're in other states. I had a client recently. She had been called and ended up signing up with a law firm based out of California. And to no surprise, she wasn't happy with the service that she was receiving from this California-based law firm, and so she fired them. And thankfully they decided to cooperate with that process and to release their interest in the case. But sometimes some of these unscrupulous firms, they'll say, sure, you can fire us, but you signed a contract and you still owe us 40% of your case, whether we represent you or not.
Wow.
And so, in those cases, we really have to dig into the facts and find out exactly what happened and how, this attorney-client relationship came to be, and figure out what we can do, if anything. But it really screws up the process if someone else is going to take, 33 or 40% of your case. Then that doesn't leave a lot for us to work with on our side of it. And so it's hard to help in some situations.
It's astonishing to me that kind of contract could be illegal in this industry, I guess. Have you I guess you've told me before, you've dealt with numerous clients who have come from bigger billboard law firms, both in-state and out-of-state, as that example. What's the process usually like, assuming they're not, hampered by a 40% contract they've signed on, whether or not the other firm takes the case?
Right. So if you call me up and you say, hey, I was represented by this firm, that you may recognize the name of, or you might not recognize the name of, but I was represented by a firm and they have dropped my case. Can you help me? Okay, well, that's probably an indicator that I need to really scrutinize the case. I need to meet with you. I need to figure out why exactly the other firm dropped the case. And I need to know all of the details of your case so that I can tell you if it's something that I can help with or not. In some situations, there might be a very legitimate reason of why they dropped your case. And, they might have figured out that you were actually at fault for causing the wreck. If that's the situation, I might not be able to help you with the case. But in many cases, the reason that some of these larger firms drop cases is because they don't want to put in the work that's required on some cases. They have so many cases waiting in their inventory of cases that it's in their interest to settle the cases that they can settle and drop the cases that need the actual work done on them. And so I had a case recently where the client had been dropped by one of the large firms that you see advertising on TV, one of the ones that yells really loud and pounds their fist and tells you all the ways that they're going to get the evil insurance company. And they had dropped her case with about 3 months left in the statute of limitations. So it's what we call a short fuse. Something has to be done within the next 3 months to either settle this case or a lawsuit needs to be filed. And she had called quite a few other firms and no one wanted to touch it because they're scared of this short fuse. Well, she came in and met with me and I reviewed her case and I said, okay, yeah, I think it's something that we can help you with, and we'll go ahead and get a lawsuit on file. And so we're not worried about this three-month statute of limitations coming up. And we got our case settled last week for good money, money that gets all of her medical bills paid and puts a good chunk of money in her pocket after working on the case. And
Yeah.
so that's something that does happen is these larger firms, they just don't want to work on cases that they believe are not worth their time, or that they think are going to be more work than what the reward that they're going to get out of it is. But for a smaller firm like myself, those cases are good cases for us. We can do work on them. We can make money, and the client ends up doing well, and everybody's happy.
Mhm.
Yeah.
As opposed to a bigger firm thinking, after just looking at it for however long they look at it, or putting it through their algorithm or whatever that looks like,
Right.
to say, hey, we probably just not enough meat on this for us, so we're going to drop the case. As it makes no difference to them. They have the opportunity cost of going through even bigger cases to find what they want to work on.
Right. Yeah. A lot of these really large firms, they want the easier cases. They want the cases where the damages are really high, the people are really badly injured, and in some of these cases, they can simply send a demand letter, and hey, pay us the full amount of your policy limits. And the insurance company looks at it and is like, okay, this person is really badly injured. This case is probably worth way more than the coverage that we have. And so it makes sense for us to pay the policy limits and settle the case. And so they get these big firms, they get paid on that type of a case, and then they move on to the next type of, the next case that they have. And so when they come across a case that is going to require, months of work, they don't want to do that type of a case. They'd rather drop it and let that person go find someone else to help them.
Yeah. Can you talk about what it's like when you've got, someone giving you a call and they just gotten in an accident and they're like, hey, it's okay, a police report was filed. I don't have any witnesses, but the police were there and they took the report, and I'm going to get the report, access to the report sent to me or anything like that. What does that typically look like in terms of their expectations you're used to seeing and how it actually plays out?
Sure. So people, I think the general public, but then also a lot of attorneys that I've come across in my experience, have this expectation that a crash report or a police report is going to be the absolute truth and is going to illustrate exactly what happened in an incident. And in my experience, I've found that to be not true in many cases. I look at the crash report as sort of a starting point. Here's some information about who was involved in the wreck, where did the wreck occur, what time did it occur, what day did it occur on. But it's gotten almost to the point where when we get a crash report that doesn't have major errors in it, we're surprised. It's really gotten to be that bad, where we get a crash report and we're like, okay, yes, this is true, this is true, this is true, yep, yeah, this all looks good. Okay, somebody did a good job in this situation. But the norm is that, okay, why does it say both people have the same insurance policy number? Like, that's not accurate. Why does it have USAA's phone number, but it says that there's a Geico policy? That doesn't make sense. Why does it say this person was going this way? Or why does it say that this person was distracted? What's the basis for these statements in this report? There's just so much opportunity for errors and so much opportunity for misinformation in a crash report that we really don't rely on them that much. And so it's just something that we use as information and a starting point but we really have to conduct our own investigation and hire our own experts to figure out what really happened in many cases.
Does there become a point with police reports, crash reports, where it's almost inadmissible in court because of, erroneous inaccuracies, things like that?
Sure. Most of the time we can file what's called a motion to exclude. And so we'll ask the judge, we need this information excluded because it's unreliable. And so in order for something to be admissible to a jury, admissible at a trial, that information has to be reliable, meaning that it's based off of evidence that we can see and that other people can see, and it's based off of truth. And so often when an officer responds to a crash, they didn't witness the crash happen. They show up and they get there 15 minutes, 30 minutes later, and they, well, did you see what happened? Well, yeah, here's what I think happened. Okay, well, did you see what happened? Yeah, here's what I think happened. And then they kind of, make their best educated guess at what they think happened, and they write it down. And so that their opinion is oftentimes excludable as hearsay because they did not witness the crash. And they're also, in most cases, not qualified to do an actual accident reconstruction. And so they're not, calculating forces. They're not figuring out, well, this, based on the damages here, this vehicle, I think, was going 30 miles an hour, or, they're not piecing things together. They're just really regurgitating hearsay information that's been given to them at the scene.
And I think it's human nature, just based on survival instincts, to make snap judgments. And all police officers, to my knowledge, are human, right? So
Yeah, right.
a lot of that is probably pretty natural, that they're coming up with, well, that person seems like they might be the guilty party, so likely they're guilty. And they may not put that on paper, but they might put other things, in a biased manner on paper. I'm not saying all police officers do that, but it's probably worth, unpacking, their core function is to make sure that the roadway is safe for people and to get them back on the road or off the road as quickly as possible, right?
For sure, yes. Most of the police officers that respond, unless they're, part of a specific accident reconstruction unit that goes out and responds, when there's a fatality, for example. In the vast majority of crashes that happen, the responding officer is just there to sort of patrol the traffic, make sure that the traffic can continue to flow around the accident, make sure that the vehicles get taken care of, make sure that the people get taken care of, and to record basic facts. That's really it. And there's really no expectation, no legitimate expectation that these officers who are responding are actually figuring out what happened in a crash. They're really not equipped to do that. They don't have the time, they don't have the training, they don't have the tools. And so, it takes me back to the point about dash cams. That's really the best thing you can do to protect yourself. And then if there are witnesses, get that witness's information. And so preserve that information, because a lot of officers that I've seen myself, for some reason, they don't feel that that's important to preserve witness information. And I've seen officers on multiple occasions simply dismiss witnesses, and it's very frustrating.
Speaking of witnesses, is there a difference in the definition between a witness and an eyewitness?
We think about a witness, whether you say witness or eyewitness, kind of the simple definition that you think of is that person saw something happen. And so in multiple situations, we've had cases where there have been alleged witnesses, and the witness influences the officers. You know, the witness says, yeah, this is what happened. This person cut this person off, or this person swerved around, and then this is how the wreck happened. And these officers, you know, they're kind of taking this at face value and believing what is told to them. And then, you know, once we get involved in the case and we do some further digging, and you know, sometimes we end up getting these witnesses in a deposition, meaning we're able to ask them questions to really figure out what they did see or what they didn't see. And one question that I always ask a witness or an alleged witness is, how do you know that a wreck occurred? Well, I heard it. Okay, so the first indication that you had that there was a wreck was that you heard something. That means you did not see it happen. And so, you know, people's brains, our brains, they like to fill in missing details, because our brains like to have a complete picture of what happened. And so a person will hear a crash happen, they'll turn around, they'll see the aftermath of it, and then their brain will reconstruct what it thinks happened in the crash, and then that person will regurgitate that or share that as a truth. And it's hard, because the tendency is we want to believe witnesses, right? You think about a witness, an independent witness, right? They have nothing to gain by sharing what they think happened, right? They're trying to be helpful, they're trying to be unbiased, and they're trying to say, hey, I witnessed this, here's what I saw happen. Well, in many cases, it's not helpful, and it's actually hurtful, because they didn't actually see what happened. So if a witness legitimately saw what happened and can share their testimony, that can definitely be helpful. But when it's a situation of, I heard this wreck happen, and then I think I know what happened, it's better to not share that information.
So for the crash reports, is there ever a time, or a police report in general, where things can be changed after the fact?
So changing a crash report is difficult for several reasons. One reason being that officers are busy, and they don't really have time to revisit every single crash report that they've written, and they're not interested in revisiting every single crash report that they've written. And so a lot of times a request to to an officer, like, hey officer, some additional information has come to light, and we think that this crash report is wrong as a result. A lot of times that's not well received, and like I said, because they're busy. Another reason is they don't want to admit that they've made a mistake. They have their egos and their pride that they're trying to protect, and they don't like being told that, hey, we think this is wrong, we think that you made a mistake. They don't want to hear that, and so they kind of ignore some of those communications sometimes. And so really the best remedy that we have sometimes is, once we get into a litigation and we have a crash report that's wrong, the best remedy that we have is to really file a motion to exclude that crash report, like we talked about earlier, where we can say to the judge, look, we have evidence that's contrary to what is written here. We've deposed this officer, we've produced their training record that shows they're not trained as an accident reconstructionist. They don't have the knowledge, training, and experience to talk to a jury about why a crash happened. And so for these reasons, we're asking this crash report to be excluded. And that takes away the misinformation. It eliminates the incorrect information from the possibility that it can taint the jury. And then it allows us to kind of start from scratch and to really prove what did in fact happen. And so that's the best way that we can really counteract wrong information in crash reports.
Okay. So let's talk litigation. And you had mentioned, depositions. If you can just provide, what is a deposition, and is it something that just happens to your clients, or, do you depose other parties? How does that work?
Sure. So any party to a lawsuit, whether it's a plaintiff that I'm representing or a defendant that I'm suing, can be deposed in a lawsuit, and then witnesses, independent witnesses or independent people can be deposed, and expert witnesses can be deposed. And so for a deposition, the simplest description of it is we're getting to ask you questions in front of a court reporter. And so, prior to COVID, depositions were done 99% of the time in person. You would go to your attorney's office, or you would go to the other attorney's office and have a setup with a court reporter there in person. Sometimes they're videoed. The court reporter says, raise your right hand, and they give you an oath to tell the truth, just exactly like if you're sitting in a courtroom. And the other attorney gets to ask you questions. And for the most part, with very few exceptions, you have to answer their questions. And so it's a very powerful tool because it lets us conduct widespread discovery into things, and it lets us really get to the bottom of issues, and it lets us get unfiltered answers, right? Because when we do written discovery, for example, we send written questions to a party, and then they get to sit there with the help of their attorney and answer the questions. And so we're getting answers that have been filtered through the attorney rather than, truly candid answers. And so we do find depositions are very helpful in many situations.
And do your injured clients at times also get called in for a deposition?
Yes. In the vast majority of cases that we litigate, the client does get deposed. And my clients, they're often pretty stressed about that, and it is a stressful concept, but I reassure them, as long as we're here telling the truth, it's not a stressful process. All they can ask you is what you know. They can't force you to answer things that you don't know. They can't force you to answer things that you don't remember. So if you don't know the answer, I don't know. If you don't remember, I don't remember. And that's it. And so, we're here telling the truth, and we really don't have anything to worry about in a deposition.
Is there ever an answer in a deposition for your clients that trips them up, or that could sway an outcome of a case?
Sure, yeah. I mean, it's easy in a deposition because the other side will try to kind of rush you through it, and they try to control the cadence of the questions and of the answers. And something I tell my clients before they get deposed is go slowly. Listen very carefully to the question. Listen to the question. Wait until the question is completely done being asked, and then think about it. Before you give your answer, think about your answer. That gives me a second as your attorney to decide if I need to do something, if I need to make an objection, or if in a rare instance I need to tell you don't answer a question. That gives me time, and it also gives you time to think about your answer. And so I think that's the best advice I give my clients is just take your time. Listen to the question, think about it, and then give your answer. There's no rush, there's no time limit. You're in control of this process, right?
Okay.
The other big piece of advice I give my clients is don't ever feel like you need to justify your answer. Give your answer and then stop talking, because the more you try to justify your answer, the more you try to get defensive. Why are you asking me about that? What does that matter? What does that have to do with anything? the worse it looks for you, right? And so just give the answer. Well, isn't it true you've been in 5 wrecks prior to this? Yes. You don't need to sit there and explain. You don't need to get uncomfortable. Just give the answer, be confident in your answer, and shut up. That's the biggest thing I tell my clients. Give the answer, stop talking, wait for the next question. The more you talk, the more you ramble on, the less helpful it's going to be to your case.
What's one piece of advice you would give somebody who has just gotten in an accident?
So if you've just gotten in an accident, like literally it's just happened, it's going to be like cliche advice, but try to stay calm, right? The more you panic, the worse that it's going to make the entire situation. And so stay calm, take a deep breath. You're still alive, right? As long as you're still alive, you're still here. Go ahead and call 911. Tell them, hey, I was in an accident. Here's my location. Are you injured? If you're injured, if you think that you are injured, you're feeling pain, tell them, yes, I'm injured. Do you want EMS? Yes. I'll talk to EMS. You don't have to be transported, but it's good to get checked out. If you're feeling pain, go ahead and get checked out. And if they're recommending that you be transported, go ahead and let them transport you to the emergency room. I mean, that's what they're there for. And, if you've done the things ahead of time, if you've bought the right insurance, if you've saved my number in your phone, go ahead and call your attorney, call someone and get some advice in that moment and figure out a plan. But I think taking care of yourself, remaining calm and then trying to preserve the evidence that you can preserve at the scene, I think is helpful too. So go ahead and take some photos if you can safely do it. If you're in the middle of 35 and cars are zooming past you, it's not safe. But if you're on a side street or you're on the access road and the traffic is at a crawl, go ahead and take some photos of your vehicle, take some photos of the other vehicle, take photos of where the vehicles are positioned. All of that can be helpful later on, because once the police show up, the tow trucks show up, they start moving things, they start changing things, they start sweeping debris off the ground, and some of this evidence is lost at that point.
Grant Quenstedt, Quenstedt Law Firm, where can folks find you?
Sure. So we're on Facebook, we're on Instagram, we're on YouTube now, and we're physically located here at 17323 Interstate 35 North, Suite 105 in Schertz, Texas 78154. We've been here at this location over 10 years now, in the same location, and they're able to call us anytime, 210-888-9953. During business hours, we answer the phone ourselves. After business hours, we do have an answering service. They can, you can let them know what happened with your case, and they will call my cell phone 24/7. And if I'm available, I will speak to you myself.
Right on.
Yeah.
Thank you so much.
All right. Thanks, Matt. I appreciate it.